And she says, hey guys, people who are married. And she says, hey guys, people who are married who never have a custody dispute are never affected by this. So two anti-vaxxers married to each other will never be affected. One anti-vaxxer and one vaxxer married to each other will never be affected. What else? Let's hear a couple of other contributions. So the other couple of other key points, I've already sort of highlighted this, but no one's actually getting vaccinated here. So the solution would be, good. So children whose parents never married might not be affected at all because there might not necessarily have this kind of a dispute brewing. There may be, and most importantly, no kid is getting vaccinated because of this. So the answer to this is that the non-vax parent will have a presumption imposed against them. So that might compromise the child's relationship and their access to their non-vax parent. But it doesn't actually do anything to get the child safer from disease. It doesn't actually force the vaccination. That's Mary Beth's point exactly, that it's not achieving the vaccination at all. And so, see, this is a terrible statute. It's definitely not narrowly tailored to achieving this government purpose, and so it would fail. You could also look at, you could also look and see that there are some exceptions that would protect you under those, under the guidelines below, but even that's not super relevant. You can easily analyze this just with what we've just done. Then the next thing we would do is we'd stop and consider, so the statute fails. Is unconstitutional. Then the next thing we could do is we could consider whether there's an equal protection issue here. There definitely is an equal protection issue here because they're classifying either non-vax parents and vax parents or parents going through a custody dispute and not going through a custody dispute or not vaccinating. But none of those are protected classes, which means we would just need a rational basis. And this is definitely at least a, rational, might at least be a rational statute, but we've already killed it under our first provision. The last thing I want to say, and then I'll just open up for any last questions, but the last thing I want to say is I think it can be helpful just by way of comparison to compare this to instead the real statute in Kentucky, which says that children, because of the goal of stopping the spread of harmful diseases, children cannot enroll in public education unless they can provide proof of vaccination, with some narrow state exceptions allowed. Now let's just run that through and see how different that analysis is. Is it a compelling government interest? Yes, still. But the next question is the means of achieving it, requiring children to show vaccination before they can go to public school, subject to only narrow exceptions, is that narrowly tailored to achieving the goal of stopping the spread of infectious diseases? Much, much stronger. It's a much better fit because here you're actually getting kids vaccinated. You're treating all the kids equally. It's all the kids who are enrolling in school, and you're much more likely to actually increase the vaccination rate in those cases. So you can see that's a much better example of a statute that's more likely narrowly tailored. So let me take any questions on this. My biggest advice for answering comma questions is to not get overwhelmed by seeing all that new text in front of you, and just remember you have one question to ask: fundamental right, equal protection under both, and then you follow your methodology. It's more about methodology than anything. You go through if what standard of review you're going to apply. You stop at each of those steps, and then once you do it that way, you sort of go back to the question to find the content you need to work with. But I think it's a lot more empowering if you enter this knowing that you have one real question to answer and a flow chart to follow. So any last questions on this? Yeah, Mary Beth?
I have two questions. So the equal protection issue, what's the class again? Isn't it like sex or gender?
No, that's a great question. So ordinarily, so think about equal protection as two separate things. The first question is there a classification? And then the second question is what standard of review does that classification fit? And so equal protection issues are generally getting at the idea that there are communities that have been historically discriminated against, and we should inherently be suspect of laws that are passed that treat people differently based on race, national origin, sex, and legitimacy for the purposes of our class. That's what we studied. And we should be suspicious of those statutes because there's an entire history of treating children differently out of wedlock, an entire history of race-based classifications. So we're way more suspicious of those types of regulations. So those will get your intermediate or your strict scrutiny. But any classification that doesn't raise that level of scrutiny would still get an equal protection analysis. It's just that it would only be rational basis. So that's what we would have here. The lowest level of review, the most deferential, because we have no reason to be suspicious here about how the state is regulating by vaccination. So here, I think the classification, you could phrase it a couple of different ways, but one classification is definitely parents who vaccinate their children and parents who oppose vaccinations for their children. Or another classification could be non-vaccinating parents going through a custody dispute versus non-vaccinating parents not in a custody dispute. Both either way would be classification, but it doesn't raise any sort of concern. It would just mean that the law would have to be only rationally related. So it can be more of an ill fit than a fundamental rights analysis.
Okay.
You say the second question,
yeah. So on the, so it says proposed amendments, if you think that it wants to note that. So is that where we would just say what you just did about if it was about the education, if it was about vaccination records for that? Is that what we would say? Or
and not everybody does this, but if you can think of anything, like here, you can even say that a decision to vaccinate your children would override this presumption. That would definitely get it way closer because at least then you'd have kids that were, or you could tie it to this plus child support or something, something that gets more kids into this. But so you could try to make it a better fit if you can brainstorm a way. This one's not really screaming out for a way to do that. It's kind of just a bad statute, but sometimes it's a really simple one. So for example, when we did our practice questions a few weeks ago, one of the practice questions involved a 20-week ban. And an easy solution to try to save a 20-week ban on abortions after 20 weeks would be to say, I think it was a 6-week ban, but would be to say, except for the life of the mother. That's a great exception that would get at the other competing interest in protecting the health and life of the mother. Cool. Any other questions? Okay. Cool. I'm going to stop recording just in case. Any other questions now that we're not recording? You guys are awesome for working through this. Definitely swagger is the name of the game for answering comma questions. If they try to break it down, try not to be intimidated by them, try to just bust into them with the swagger that if the state needs to do so under the carefulest of drafting, and you're just going to really critique to kind of blow up the logic and the rationale for how the statute isn't very well doing what it seeks to do. Cool. If you guys don't have any more questions, we'll close up for the night. It's good to see you guys. Reach out and feel free to reach out. I have office hours tomorrow at noon. I have office hours Sunday, I think, at noon. I still have more office hours, and I'm happy to answer questions by email, by text. I'm here to help you guys succeed.
We did that. We did that. Okay.